Hi friends, now discuss State Human Rights Commission. It is Indian polity. So let's start. The Protection of Human Rights Commission Act, Protection of Human Rights Act of 1993 provides for the creation of not only the National Human Rights Commission but also the State Human Rights Commission at a state level. Accordingly, 25 states have constituted the State Human Rights Commissions through official gazette notification. A State Human Rights Commission can incur in a violation of human rights only in respect of subjects mentioned in the state list 2 and the concurrent list 3 and the 7th schedule of the Constitution. However, if any of such case is already being incurred into by the National Human Rights Commission or any other statutory commission, then the State Human Rights Commission does not incur into that case. Composition of the commission. The State Human Rights Commission is a multi-member body consisting of a chairperson and 2 members. The chairperson should be the retired Chief Justice of the High Court, and members should be a serving or retired judge of a High Court or district judge in the state with a minimum of 7 years experience of district judge, and a person having knowledge or practical experience with respect to human rights. The chairperson and members are appointed by the governor, and the recommendation of a committee consisting of a chief minister as its head. The Speaker of the Legislative Assembly, the Speaker of the Home Minister, and the leader of the opposition in the Assembly. Opposition in the Legislative Assembly. In the case of a state having legislative council, the chairman of a council and the leader of the opposition in the council would also be the members of the committee. Further, a sitting judge of a High Court or a sitting district judge can be appointed only after consultation with the Chief Justice and the High Court of the concerned state. The chairperson and members hold office for a term of 5 years or until they attain the age of the 70 years, whichever is earlier. After the tenure, the chairperson and members are not eligible for further employment under a government, state government, or the central government. Although the chairperson and members of the State Human Rights Commission, are appointed by the governor, they can be removed only by the same grounds and in the same manner, and as he can remove the chairperson or a member of the National Human Rights Commission. Thus, he can remove the chairperson of a member under the following circumstances: if he is adjudged or insolvent, if he engages during his term of office in any paid employment outside the duties of his office, if he is unfit to continue in office by reason of infirmity of mind or body, if he is of unsound mind and stands also declared by a competent court, or if she is convicted and sentenced to imprisonment for an offence. In addition to this, the President can also remove the chairperson or a member on the ground of proved misbehavior or incapacity. However, in these cases, the President has to refer the member to the Supreme Court for an inquiry. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, then the President can remove the chairperson or a member. The salaries, allowance, and other conditions of service of the chairman or a member are determined by the state government, but they cannot be varied to his disadvantage after his appointment. All the above provisions are aimed at securing autonomy, independence, and impartiality in the functioning of the commission. Functions of the commission. The functions of the commissions are to inquire into any violations of human rights or negligence in the prevention of such violations by a public servant, either suo motu or on a petition presented to it on an order of a court to intervene in any proceedings involving allegations of violation of human rights pending before a court, to visit jails and detention places, of study the living conditions of inmates and makes recommendations thereon, to review the constitutional of other legal safeguards for the protection of human rights, and recommend measures for their effective implementation, to review the factors including acts of terrorism that inhibit the enjoyment of human rights, and recommend remedial measures to undertake and promote research in the field of human rights. So, to spread human rights literacy among the peoples and to promote awareness to the safeguards available for the protection of these rights. Okay, so to encourage the efforts of non-governmental organization working in the field of human rights to undertake such other functions as it may consider necessary for the promotion of human rights. Working of the Commission, is vested with the power and to regulate regulate its own procedure. It has all the powers of a civil court, and its proceedings have a judicial character. It may call for information or report from the state government or any other authority subordinate thereto. The Commission is not empowered to inquire into any matter after the expiry of 1 year from the date on which the act constituting violation of the human rights in alleged to have been committed. In other words, it can look into a matter within 1 year of its occurrence. The Commission may take any of the following steps during the or upon the constitutional completion of an inquiry. Okay, it may recommend to the state government or authority to make payment of compensation or damages to the victim. Okay, it may recommend to the state government or authority the initiation of proceedings, okay, for prosecution or any other action against a guilty public servant. It may recommend to the state government or authority for the grant, okay, of immediate interim relief to the victim. It may approach the Supreme Court or the State High Court for the necessary directions, orders, or rights. From the above, it is clear that the functions of the commissions are mainly recommendatory in nature. It has no power to punish the violations of human rights, not to award any relief, including the monetary relief to the victim. Notably, its recommendations are not binding on the state government or authority, but it should be informed after the action taken on the recommendation of within 1 month. The Commission submits its annual or special reports to the state government. These reports are laid before the state legislature along with a memorandum of action taken on the recommendations of the commissions and the reasons for non-acceptance of any of such recommendations. Human Rights Court, the Protection of Human Rights Court, Rights Act 1993, must provide for the establishment of Human Rights Court in every district for the speedy trial of the violation of human rights. These courts can be set up by the state government only with the concurrent of the Chief Justice and of the High Court of that state. For every human rights court, the state government specifies a public prosecutor or appoints an advocate who has escaped for 7 years as a special public prosecutor. So thank you, friends. Next we discuss other topic. Okay, so it is we discuss now again other topics. So thank you, friends.